Geoff Budlender, can you tell us how the South African Constitutional Court has grappled with precisely these kinds of complex questions of resource allocation?
Our Constitution obliges the state to take reasonable measures within its available resources. And so the question the courts have grappled with is, what is a reasonable measure? The courts have said from the outset, it's not for us to determine the budget. The budget is to be determined by the democratically elected representatives of the people. But how the budget is spent has to meet certain criteria. Firstly, it has to be progressive. It has to move forward in meeting needs, not be regressive. Secondly, the requirement of what is reasonable has been given some texture. For example, the courts have said something which is unequal is not reasonable. The courts have said reasonableness requires that priority be given to those who are most in need. So there is a pro-poor tilt to the required by the Constitution because, says the Constitutional Court, ours is a transformative Constitution, trying to put an end to the consequences of decades of dispossession and discrimination. The Constitution is transformative. It aims to end the consequences of inequality and poverty. And so there must be priority given to those who are poor. Thirdly, the Constitutional Court has said there must be provision for those who are in emergency and crisis situations. It's not enough to have a program which will meet everybody's needs in the long term, because in the short term, people may be dead. Rather reversing Keynes's doctrine. And so you have to have some provision for those who are in crisis today. You can't say, well, put your name on a waiting list and you'll be dealt within 15 to 20 years and we'll deal with everyone equally if there's a real crisis today. And so the courts have managed to give some texture to the notion of what is reasonableness, and have found ways to apply legal tests and legal criteria to policy decisions, and illustrated by two famous cases. One, a case called Subramani, which was a case about a man who was critically ill, dying, and needed dialysis, kidney dialysis. And there was a limited number of dialysis machines available, and he didn't meet the criteria which had been allocated. And the court said, well, there's a limited number of machines available. We can see that the criteria are reasonable. They're given firstly to those who are in critical need. They are not given to those who are in the process of dying from other diseases. They're given to those to whom they can provide some relief, preferably not firstly to people who are not in chronic situations. There was a series of criteria, and the court said that's fine. It's a tragedy that there aren't enough dialysis machines around, but it's not for us to say how the health budget should be constructed as to how much should be spent on primary, secondary, and tertiary care. And Mr. Subramani didn't get his machine, and he died. I think it was the hardest decision the Constitutional Court has made in its 13-year history. Contrast that with the treatment action campaign case which you mentioned, where there was a program in place to provide treatment to prevent pregnant women from passing on HIV virus to their infants. It was available only in 10% of the public healthcare facilities. The evidence showed that it could be done at very limited cost, that in fact there would be a net saving to the public healthcare system because the children wouldn't become ill. And the court said it's unreasonable and irrational to say we're going to provide a proven, safe, cost-effective and affordable program to only 10% of the children who are in public healthcare facilities, and it ordered the government to implement a nationwide program. And so the courts have found a way to give some texture to this notion and to not become the principal resource allocators. One other thing I do want to say, it's really a great myth that it's only social and economic rights which carry a cost. Any right which places a positive obligation on government carries a cost. And we've had illustrations of that in our courts. The right to vote, the civil and political right, has a cost. The government was ordered to make provision for prisoners to vote. And the government said this is going to cost quite a bit of money, and the court said, well, that's tough. Everybody has the right to vote. We've had cases involving equality and social welfare grants, which have a cost, and the court has said, well, equality is not negotiable. It has a cost. But you must treat everyone equally. You can treat everyone less well, but you must treat everyone equally. And so the notion that it's only social and economic rights which have these costs is simply a myth and a fallacy.
One follow-up question. The decision in the treatment action campaign case was revolved around this really unreasonable denial of access to nevirapine. Couldn't it just have been reviewed as an administrative decision that was arbitrary and unfair? I mean, there is such a mechanism for reviewing decisions, and why do you need to invoke the right to health? What did the right to health add in this case?
Well, our law follows really the English law model as to when a court will set aside an administrative decision on the grounds that it's unreasonable. Those are very limited grounds because the courts give the widest possible scope to decision makers, policy makers, as to how they're going to do it. There was a long debate in our legal team as to whether we could have won the case without a right to health. I think most of us felt that we probably couldn't have won it, that without the positive health right of access to healthcare. Remember, it's not a right to health, it's a right of access to healthcare services, a very different thing. But without that right, we thought the case could probably not have been won on traditional administrative law grounds.
So it lowered the threshold.
It lowered the threshold because what it said to the courts was, here's a primary test which you apply. Don't focus your mind on our very traditional rules of judicial intervention in policy decisions. Ask yourself the question, is it reasonable to act like this when there is a right to healthcare services? Not is it reasonable in the abstract. That changes the whole nature of the debate.